Chapter 18. Conflict of laws, or what law governs. Section 193. In general, suppose a note is made in Pennsylvania, payable in Ohio, endorsed in Kentucky, and suit is brought upon it in Illinois, and suppose each of these states has a different law, which law will govern? As a general rule, the validity of a contract in the form of a negotiable instrument is to be determined by the law of the place where it is made, and if valid where it is made, it is valid everywhere, but if invalid there it cannot be enforced in another state. If the instrument is made in one state to be performed in another, it will be governed by the laws of the state in which it is to be performed. The formalities essential to the validity of a contract and the interpretation thereof are to be governed by the laws of the country where it is made. Suppose a note is made in one jurisdiction and suit brought in another jurisdiction. What rule governs as to the bringing of the suit? The law of the latter state. A man cannot come from another state and sue on a note under the common law, but must sue according to the law in the place where he sues. In some states, in order for a note to be negotiable by the law merchant, it must be payable at a bank. Now suppose someone gets such a note in another state where such is not the law, and he endeavors to recover upon that note. In order to show the law of that state, he must introduce the special statute, because the court would presume that the common law prevailed. In order to show that the formalities were different in that state from what they are in another state, that special statute would have to be produced and introduced in evidence in another state to prove that, and if it is not introduced in evidence, then the common law would prevail. In order to have the statute to govern, the statute must be produced in another state to make it supersede the common law there. For if a note is executed in one state and suit is brought on it in another state, in the absence of the statute of the first state being pleaded, the common law prevails. If a bill on its face is an inland bill, the fact that it was actually drawn and delivered in a foreign state will not divest it of its inland character. The principle is that it is competent for the parties to provide, by agreement, that it shall be governed by the laws of any particular state or country. Section 194. As to validity, interpretation and effect. The validity of a bill or note as regards requisites in form is determined by the law of the place of its issue. As a negotiable instrument is not binding upon the parties until it is delivered, the place of contract is, therefore, the place where the instrument is delivered and not where it is written, dated and signed. But in the absence of evidence to the contrary, it will be presumed that the instrument was executed and delivered at the place where it bears date. Where the instrument specifies a place of payment in a different state from that in which it was executed and delivered, it is governed by the laws of the state in which it is made payable as to the requisites of form and execution. The question of the negotiability of a bill or note is to be determined by the law of the state where it is made payable. A note payable generally and negotiable in the state where executed will be governed by the law of that state in case suit is brought there on the note after it has been endorsed in another state where it is not negotiable. But it has been held that when a note is executed in one state and made payable in another, that it will be governed for the purposes of negotiability by the law of the state where payable. Section 195. As to liability of maker, drawer and acceptor, the obligation of the maker of a note is governed by the law of the place where the note is made or to be performed. If a negotiable note is made in one state and payable there, and it is afterwards endorsed in another state, and by the law of the former, equitable defenses are let in favor of the maker, and by the latter excluded, what rule is to govern as to the holder? The answer is, the law of the place where the note was made. For the maker undertook to pay, and the subsequent negotiation did not change his obligation or right. The contract of the drawer of a bill of exchange is governed by the law of the place where the bill is drawn, in regard to the rights of the payee and any subsequent holder, and not by the law of the place where accepted. This is so since the contract of the drawer is to pay the bill in the place where it is drawn, in case of the failure of the drawee to accept it, and not to pay it at the place where the drawee resides. The liability of an acceptor of a bill of exchange is governed by the law of the place of his acceptance, as to the drawer, payee, and each subsequent holder, provided payment is to be made in the state where the acceptance was made. If payment is to be made by the acceptor in another state, the laws of that state will govern as to these matters. Section 196. As to payment, interest and damages. The obligation of the maker to pay and that of the acceptor to accept is governed by the law of the place of performance. Therefore the rate of interest will likewise be governed by the same law. And if the different parties to the instrument reside in different jurisdictions, the law of the place where each is required to perform his obligation will govern in respect to interest. The maker of a note or the acceptor of a bill has a right to elect whether the legality of the rate shall be determined by the law of the place of payment, or of the place of execution. If a rate of interest is expressly provided for, which is usurious according to the law of the place of execution, and lawful according to the law of the place of payment, or vice versa, it will be lawful interest, and may be recovered anywhere, even in the place where the rate is declared to be usurious. But if the provision of the law, which applies in the determination of the legality and rate of interest and damages, is not established by proper testimony, the law of the place where suit is brought will govern. The rate of interest payable as damages is determined by the law of the place of performance. Thus, in case of the acceptor or maker where the instrument is payable, and in case of the drawer and endorser, where the contract of indemnity is to be performed, that is, at the place of drawing and endorsing. Section 197. As to liability of endorser. The liability of the endorser is said to be governed by the law of the place where the endorsement is made. It is the new liability created by the endorsement in favor of the endorsee and subsequent endorsers that causes this law to govern. This law governs only as to the new liability created between the endorsee or subsequent endorsers and the prior endorsers. The rights of the transferee or endorsee against the original parties to the instrument are determined by the law of the place where the contract was made or is to be performed. Each successive holder of a commercial instrument has the same rights against the acceptor or maker, it matters not where the transfer was made. These rights are determined by the lex loci contractus vel solutionis. The law of the forum determines always in whose name the suit may be brought, and to that extent governs the determination of the title of the endorsee. Section 198. As to presentment, protest and notice. The required formalities in respect to presentment are determined by the law of the place of acceptance or payment or, as sometimes called, the law of the place of performance. This needs no explanation, as no other law could govern as to presentment except the law of the place of performance. The law of the place of payment governs as to the requirements in respect to protest. If a bill is protested for non-acceptance, the law of the state where the bill was presented for acceptance will govern, while if it is presented for non-payment the law of the place of payment will govern. The authorities are divided as to what law governs the requirements in respect to notice. But the weight of American decision is to the effect that the notice must conform to the law of the place where the contract of the maker or endorser is to be performed. Section 199. Rule in federal courts. In the courts of the United States, the decisions are in general in conformity with those of the state courts of last resort in respect to the liability of parties to bills and notes, but not uniformly. Where any controversy arises as to the liability of a party to a bill of exchange, promissory note, or other negotiable paper, in one of the federal courts of the United States, which is not determined by the positive words of a state statute, or by its meaning as construed by the state courts, the federal courts will apply to its solution the general principles of the law merchant, regardless of any local decision.